Good morning, everybody.
Morning.
Morning, Judge.
Welcome to another session of oral arguments before the 5th DCA by virtual process of Zoom. Today, we have one case on our 9 o'clock docket, and that's case number 23-0645, Geico Insurance Company versus Sao. Is that how you pronounce it?
That is how you pronounce it, Judge.
Okay, great. My name is Jim Edwards. I'll be presiding. With me are Judge John Harris and Judge John McIver. If you have any kind of noise-making devices, please put them on silent or vibrate. Don't turn your phone all the way off. If somehow we lose you, that's how we get you back. But if you leave it on ring, it's guaranteed to ring at exactly the worst time. Both sides will have 20 minutes. For the appellant, we typically reserve 5 minutes. If you want something different, just let us know and we'll make that adjustment. There is a clock up in the corner, at least on my screen, it's up in the corner, and it shows 20 minutes. That's total time. It has a green light when you are still into your initial time, yellow when you get into your rebuttal time, and red when it's time to stop. Since it's not as easy to see as it might be if you were in person, I will keep an eye on it. If I see you're going into your rebuttal time and don't seem to be noticing, I may mention that to you. Your 20 minutes are your 20 minutes to do with as you please. And if you are not speaking, please go ahead and mute your microphone so that we don't get any feedback. And with that, counsel for appellant, you may proceed.
Thank you, Your Honor. May it please the court. Karen Bellis of Kubicki Draper for the appellant Geico. And I would like at this time to reserve 5 minutes for rebuttal. Thank you. Geico is here today seeking a new trial because it did not receive a fair trial below. I'd like to begin at the end. What the jury heard last, that was the culmination of plaintiff's improper theme in this case. And this is at page 2809 of the record, which is the beginning of closing arguments. To live in a land where somebody purchases insurance to protect us against the very unlikely event of a terrible car crash, and a crash like that happens. But then the insurance company says, no, we don't believe you. This is just one example of the repeated improper comments and theme of plaintiff's case, which were preserved by timely objection and motions for mistrial. And this included all the way back to 2 mistrials in voir dire and opening statements. These all warrants a new trial. Just after the comment I mentioned, Geico immediately objected, moved for a mistrial essentially on 2 grounds, and had many motions beforehand, but here Geico moved for mistrial based on not believing the plaintiff and impugning the insurance company for disputing a claim. In response, with all due respect, opposing counsel was unapologetic, despite much case law, that these were perfectly acceptable closing arguments. In fact, counsel said, this whole case has been an attack on the believability of the plaintiff. She's exaggerating. So I'm entitled at this point to argue to the jury that under the Constitution, when she is told she is exaggerating and not worthy of belief, she can have the decision made by this jury and not her insurance company. That's perfectly proper closing argument. As explained at trial, it is absolutely not. It impugns the insurer for defending a case. The issues of the insurer's behavior, claims handling, the purchase of a policy, disputing a claim are always improper, especially in a first-party case. The case law has repeatedly reversed for these kind of comments, and I would direct the court to many cases cited in our brief, but State Farm versus Revuelta, calling into account a UM insurer, Purchasing an insurance, reversible error. State Farm versus Gold, failure to take responsibility after the purchase of a policy. Purchasing exactly for this purpose and the carrier not upholding its obligations. Allstate versus Maroda, the failure of a insurer to accept responsibility. Carval versus Penjal, again, just like this case. We purchased insurance, so if she was hit by someone, that's exactly what happened here. The trial court repeatedly overruled these objections despite the fact that none of these issues, the denial, the payment, the purchase of insurance, are completely irrelevant. Now, this closing argument was actually conducted by 3 of plaintiff's counsels. It was split between 3 attorneys. And these comments continued by all 3 attorneys over objection. And I back up just for a moment, about 4 pages earlier. If it doesn't turn out quite as rosy as Geico would portray, this is her only day in court. We ask for justice. Here, Geico had objected, page 1070, 1071, to the concept of justice and repeated concepts of justice. These were again overruled. And again, right after these objections, if this wasn't enough, plaintiff returns to, and this is page 2814. As I was saying, we're fortunate to live in a land where if somebody purchases insurance, and a crash like this happens, and the insurance company says, no, we're not going to believe you. We're not going to accept your claim. She has a constitutional right not to accept that. To say, wait a minute, you know what, insurance company, I'd rather have this decision made by a panel of citizens than a bureaucratic ruling on an insurance claim. These are all improper. And if this wasn't enough, during closing argument, counsel then began to tell a long, irrelevant history lesson about the Florida Constitution. And we had 4 African Americans on the jury and 4 women and a woman plaintiff. Justice, buying a policy. If these weren't enough, then counsel went into a long lesson about the barbaric times before the Constitution in Florida, the violent displacement of persons and repression of the native peoples, where most people were engaged in human chattel and slavery. Women, again, a woman plaintiff, 4 women jurors, had no rights beyond those given to their husbands. Again, objections, mistrials, currying favor, justice. This was the theme of plaintiff's case. And repeatedly, Geico again moved for mistrial. Here on justice, the comments continued, and so much so that just about 4 pages later, Geico went again sidebar and requested standing objections explaining it didn't want to have to get up and it didn't want to have to keep interrupting. Requested, was given, and the plaintiff agreed to standing objections on concepts of justice. And then another standing objection on the concept of believability. Again, the trial court set in motion this, by overruling these objections and not granting these repeated mistrials, this theme that continued through closing with repeated another 10 perhaps comments on delivering justice, not leaving it up to her insurance company, her testimony not being good enough for Geico. Geico again renews its mistrials. And again, if this isn't enough, the very last thing, when the 3rd of plaintiff's counsel gets up in a rebuttal closing argument, he accuses defense counsel of having a selective memory. He quotes Martin Luther King as saying, do the right thing. Again, an objection overruled. And going back to the case law, the last couple of things that are said in closing argument is Geico continues to duck its responsibilities. Objection. They don't want to be held accountable. This is the everybody but the Geico defense. These comments created an environment that was prejudicial, unfairly prejudicial to Geico and requires a new trial. You know, plaintiff's brief would have you believe that this was just, they put on enough evidence. The Geico wasn't believed, the plaintiff was, that these were intermittent comments, not a theme. It's not true. In fact, the theme permeated every step of this case and was especially harmful here in the context of an underinsured motorist carrier who had admitted injury causation and some amount of damages. And this theme combined with what began with plaintiff's fifth motion in limine, the motion to exclude the fact that this was an underinsured motorist claim and refer to this as an uninsured motorist claim, led to the misidentification of Geico throughout trial. It led to the jury being inflamed and prejudiced into believing that despite admitting liability and causation, Geico refused to pay. That's what they repeatedly said. This was a charade. This was exactly the type of charade that the Supreme Court doesn't allow. And you know, not if these things weren't enough, again, during voir dire, Geico had objected. This was actually the third trial. Geico had objected back at the fifth motion in limine at all three trials to this reference misidentification of uninsured motorist claim. Plaintiff over objection, again, objections repeated throughout the three trials, to a slide during voir dire, being up on the screen, uninsured motorist. A juror, Juror Sola, while that slide is up, says, if this is about the carrier not paying the money, she should be paid the money. Geico moved for mistrial, moved to strike the panel early on because this theme had already begun.
Counsel, let me interrupt you for just a minute. You had also raised several evidentiary matters. We trust me when I say we've read the briefs, both sides very thoroughly on the record. Do you want to address your evidentiary matters? It's your time, but I'd like to hear a little bit more on some of those, including the employment angle of whether the neurosurgeon should have commented on her work expectancy.
Yes, Your Honor, I'd be happy to. So I believe what Your Honor is referencing is Dr. Canestra. Now, prior to trial, actually the second trial, discovery was frozen after the first trial. And plaintiff's life care planner, Dr. Robinson, had opined that there was no evidence whatsoever. And he was the only expert who was disclosed before the first trial to testify about life, work expectancy, future loss of earning ability. He testified consistent with plaintiff's pretrial testimony that she planned to work until she was 70. Plaintiff here was an active professional. She was 40 years old. She described her job as a level 1 trauma anesthesiologist as combat. She was physically active. She skied, she traveled. She had had an injection in the course of 2.5, 3 years before this trial, had only $37,000, $40,000 worth of medical bills. And what happened at the second trial, after the first trial, the judge froze discovery. The second trial, Dr. Canestra, who had not been disclosed to testify about plaintiff's lack of alleged future wage loss, opined that, and again, he had not seen her except for over 2 Zoom meetings. He had no information because she hadn't had any problem with her job. He had no information about what her job was or that she was having any problems with her job. Despite this, and despite admitting that if he really thought she had a problem and needed surgery, he'd call her in and do a physical examination, he was allowed to opine that at age 60, she would have to stop working as a anesthesiologist and would have a wage loss capacity. That trial resulted in a mistrial because of another expert being admitted to the hospital. After that second trial, Geico moved to exclude any evidence inconsistent with plaintiff's testimony and that of her life care planner, Dr. Robinson. It also moved to exclude plaintiff's tax returns. Those motions were overruled, and Dr. Canestra was improperly allowed to testify, to opine that, again, despite no treatment, no surgery, she would need to stop working in her job of choice and would have a wage loss some 20 years from now. This is completely speculative, especially in the context.
Counsel, was his testimony that if she had surgery, then she would retire? Am I not remembering that correctly?
I don't believe that was his testimony, Your Honor. I believe it was that she would be unable to do this job even with surgery, and that she would need the surgery to continue really at all to live her life, but that she could no longer work at this age 60 in her chosen profession. And the plaintiffs then used that testimony combined with plaintiff's tax return to make a future wage or loss of earning capacity claim. Geico argued this was completely speculative because it was, and in fact moved for directed verdict.
Ms. Collins, is there any reason why Dr. Canestra could not have been deposed and you could not have addressed all the weakness of this testimony on cross-examination?
Because discovery was frozen after the first trial, Your Honor. And that is, again, Dr. Robinson and the plaintiff had testified before trial that she planned to work till she was 70. She loved her job. She skied, she traveled, she drove her kids to and from camp. She bent and lifted, moved the gurneys herself. She put people under sedation, a very, very dangerous, thing and job. So there was simply no evidence whatsoever and no reason for Geico to expect this change in testimony. And then, and as the court sees,
No reason other than the fact that he gave that testimony at the second trial?
no reason other than discovery had been frozen, and that testimony was a surprise at the second trial, and after it, Geico immediately moved to exclude it. And plaintiff has the burden here of presenting a change in testimony. And it should have been excluded because it was inconsistent with all pre-trial testimony from the plaintiff and all evidence, and frankly was completely speculative. I mean, this is a doctor who saw her by Zoom and opined that 20 years from now, she'd have to stop working and have a surgery.
Counsel, as promised, I'm going to point out you have about 3.5 minutes left of your rebuttal time. So
thank you. Then I would briefly, and I believe these facts that support that there shouldn't have been a future loss of earning capacity ties into Your Honor's question about the other evidentiary issues. And I would briefly like to touch upon the tennis evidence. Plaintiff testified that she played with older women, a D team, that they sweat more from the heat than from the actual tennis. During trial, her friend, Dr. Warwick, testified that she in fact played on not just the league, the Pontevedra, I believe it was, league, a club that plaintiff had testified to, and her mother and her husband, who all said, it was like water aerobics. She didn't really have to exert herself. Her husband said it wasn't competitive. Plaintiff specifically testified that she had never played as many as 30 games, that she was not ranked.
37 matches. I think the fact that trial counsel started out with 37 matches early in the case, maybe an opening, and talked about 37 matches several times, that from what I read in the record, that seemed to suggest to the trial judge that the miraculous finding of the 37 matches the night before was a little bit hard to swallow. I mean,
Well,
can you
it's not
talk about that?
absolutely, Your Honor. And it's not just the 37 matches. It's the extent of plaintiff's physical and tennis ability. Yes, perhaps we did know about the 37 matches, but what Geico didn't know about was a second league, because plaintiff was going by another name on social media, not until Dr. Warwick testified to, I believe, the First Coast Slather League, did Geico, through friends and that league, search Facebook, social media, trial counsel's firm, search social media through this other league, and found not just the 37 matches, but the plaintiff was scheduled to play tennis 2 days after. 15 pictures of plaintiff in uniform, smiling, playing with women her own age, actively competing. These photographs and plaintiff's credibility was absolutely at issue here. And what the judge recognized when reviewing this proffered testimony was that this was troubling, that this showed plaintiffs potentially lying, would show that plaintiff's testimony was inconsistent. And it's not, again, the 37 matches that perhaps was known based on the opening statement, but what wasn't known was the other league, the extent of play, her physical ability, her competing with young people, her competing on a team, her being ranked, her playing. There were pictures of her around Christmas playing doubles matches with men, with her husband. All of this is completely inconsistent and very crucial to her credibility, where she was an active professional doing this highly physical job, but then
Counsel?
misrepresented.
Counsel, you're out of time, so
Thank you, Your Honor.
we'll move on over now to Mr. Pennington. And if you'll unmute, there you go. We'll be all set.
Yes, sir, Judge. Police Court, Rufus Pennington with Coker Law, counsel for the appellee, Dr. Brooks Howe. Judge, for some reason, I don't see the timer on here, so if the court would be kind enough to give me a heads up, maybe a couple minutes left, I'd appreciate it.
Okay, I'll give you a 5-minute warning, and then I'll give you 2 minutes if you like, so that's fine.
Sure, thanks, Judge. Let me just clear up a couple of things here, and I know this was not intentional by Ms. Bellis, but in part of her presentation, she seemed to suggest that, or imply, and maybe she didn't, but to me it sounded that way, that perhaps the 2 previous mistrials were because of something that the plaintiff did. And I want the court to understand that's not the case. The first mistrial was beyond anybody's control. It was because of the case of COVID in the panel, and there was nothing anybody could do. That was in the peak.
Well, we're familiar with that. The second one was because an expert got ill. Is that correct, or had to go to the hospital?
Dr. Foley, and that does kind of play into another point that she made, because when Dr. Foley became ill, the trial judge did not require Geico to read his deposition. They said, no, he's an important witness. Well, I'll let you call him. We're going to mistry this case this time too. But I want you to make sure that when we reset it, it's clear on Dr. Foley's calendar and we can go. Geico represented to the court when it was reset that Dr. Foley had been told he was good to go. We get the trial the 3rd time, and lo and behold, Dr. Foley is on a cruise in Alaska, and it's because Geico admitted on the record that they never actually told him about it. And I think a lot of trial judges would have said, okay, now, you're going to read his deposition or something, but the trial judge gave them another opportunity to substitute on the very eve of trial, the weekend before trial, a new retained radiologist from downstate who came up. So that was the reason for that. The reason it's important, of course, is that, and Judge McIver was exactly right, in the second trial, Dr. Canestra, the surgeon, and the reason he saw her by Zoom, by the way, was because this was during COVID and he had to see the patient by Zoom. He's a surgeon. He's not our treating neurologist. He's not our pain management doctor. He's a surgeon, and he evaluated her primarily with the MRIs and the films and said that, with these 3 herniated discs with the associated annular tears and facet joint injuries, you are going to require surgery. You're going to I can't tell you when. You, the patient, will tell me when that is. And but you're going to require it's either going to be fusion or an artificial disc replacement. And because of your young age, it's going to have to be either way. You're going to have to be reoperated down the road. Now, at that time in the second trial, Geico didn't, and he also testified that because of this, she's the maximum we can reasonably expect her to work, not work in any capacity, but work as an operating room anesthesiologist because of the physical requirements, is to age 60. In that second trial, when he gave that testimony, Geico did not object on the grounds of surprise. They objected on the lack of predicate. Predicate objection was cured, and the testimony came in without any objection about surprise. Now, the third trial, they said, no, this was going to be a surprise to us. And the court said, well, wait a minute. You didn't take his deposition before the second trial, and you're not taking his deposition before the third trial. And they made the same argument. Well, discovery's frozen. And she says, no, it's always open for good cause. And if you told me that you needed a deposition of Dr. Canestra, especially if you argued you were really surprised about it, of course the court would have allowed it. So they made the choice not to take a deposition before the second trial of Dr. Canestra and not to take a deposition after the second trial when they knew in detail, they knew his exact trial testimony was before the third trial. And the trial court found on the record that you had ample opportunity to do this discovery. Even so, however, the judge limited his testimony in the third trial to the same testimony that he gave in the second trial. So that's actually how that happened. Now, as for this impeachment evidence, I think they may be coming up with a new argument now that wasn't even given to the trial court about how these documents that they wanted to use showed, quote, another lead. But if you go and look at sounds like the court probably already has, if you look at this previously undisclosed impeachment evidence in the record, it's a website printout, publicly available, and Facebook postings, publicly available. And the trial court said, well, wait a minute, and actually asked Ms. Bellis, you agree that this material was available? And she said it was it was a public Facebook page, and that's in the record at 4676. And so the trial judge found that it was available. It just was never really researched or investigated until the trial. And that's at record page 4689. And of course, I won't belabor the court with it. It is interesting that they had the exact number of matches revealed in this undisclosed information. They didn't just say it in an opening statement. They cross-examined Dr. Sal's husband about it. They cross-examined her friend that she plays tennis with, another physician, Dr. Adrian Ward. Would it surprise you if there's a record showing that you and Dr. Sal played 37 matches in 2021 alone? They're pretty specific. That's at transcript 1700. And they even cross-examined the plaintiff's mom about the tennis matches. And of course, they cross-examined plaintiff Brooke Sal at great length on this. And, and they all said, yeah, that sounds about right. At that time, Adrian Ward says, yeah, we're playing about 3 matches a year, so 36 sounds about right. 3 matches a month. So, what conceivable prejudice could there be? If there was any prejudice, it was to the plaintiff because they got all this out in front of the jury when it wasn't disclosed. And, the Northup versus Acker, I'm old enough to remember when the Supreme Court decided that. And a lot of trial lawyers said, well, what's the fun in trying a case anymore if you have to disclose impeachment material before the witness testifies? But 20 years we've been living under Northup, and that's the rule. If it's requested, like it was in this case, and the judge's pretrial order doesn't have something different, the Supreme Court's rule stands. And we asked for it, and they didn't give it to us. They talked about it in an opening statement, and they cross-examined these witnesses about the information in it, and then they sprang it after all of the witnesses had testified. If you sat down and tried to write a classic example of a Northrop violation, you couldn't do any better than that. And so what was the trial judge really supposed to do in that situation? Given them the benefit of the doubt, they just didn't get around to doing the work until trial, and that's just not good enough. I hope I didn't use too much of my time, because I do want to turn to this issue of the
We have a little less than 12 minutes left.
Okay, good. Because I need to show the court, I think, that and Geico's done a very impressive job of it, of taking different statements, different places in the trial, from voir dire, opening statement, closing argument, and cutting them out and putting them into a collage that creates an impression that really is not how the case was tried. And that is, in case I forget to mention this anywhere else, that's really why great deference is given to the trial judge on these particular kinds of things, because the trial judge is sitting there as it's coming down in real time and hearing it in context, rather than on appeal having to go back and try to take the collage apart and put it back where everything goes. But you recall in the initial brief—
Counsel, how about explain to us why the slavery remarks and the chattel remarks were appropriate in this closing argument?
Okay,
that seems to me that one of the main arguments that appellant is making here is that line of argument had nothing to do with the case, other than to try to appeal to prejudice or sympathy on the jury. What's your response to that?
My response to that is this was not pandering or trying to inflame the jury. First of all, let me say this, Judge. You know that the closing arguments in these cases are asymmetrical by nature. And what I mean by that is this: that if you go out on the street and you ask people, one side in this lawsuit is saying that the other side is making this up. They're not telling the truth. They're fabricating it. They're exaggerating it. They're making it up out of whole cloth. And not only that, they got a whole group of doctors, board certified doctors, who are also part of this thing and are making this up, and they're not telling the truth. Now, if you said that to somebody and then you ask them, is that person denigrating the person they're accusing of this? Most people would say, yeah. And if it turned out to be untrue, they would say, yeah, you're really denigrating them. But that's okay. We get that Geico is entitled to do that. Okay, even if it's just a flimsy interpretation of the evidence. Geico is entitled to denigrate Brooke Sow in that sense. Okay. In response, it's asymmetrical because we can't get up and certainly denigrate Geico or demean Geico, but and we understand that we can't accuse them of bad faith or of pretrial conduct in the handling of the claims. Can't do that, but we have to be able to respond to their attack, to their accusation, essentially, that Brooke Sow is a fraud. We have to be able to do that. So we have to walk this line between not accusing them of bad faith, not disparaging them, not demeaning them, but forcefully responding to this really, really profound attack on the character of Brooke Sow. Now, what is the possible relevance of the history? One thing that we can do is hopefully not pander to the jury, but motivate the jury, inspire the jury to recognize the importance of their role in the case. And that's what that part of the closing argument was an attempt to do. And it wasn't just about that there was slavery or women's rights. I know the court's gone back and read it. It was really a discussion of the importance of the state constitutional guarantee to the right of jury trial, and how it was one of the first things in the territorial constitution, even before Florida was a state, And through all the constitutional amendments, through all the changes, world wars, other things, not just the changes in the, status of people that we all recognize have rights now, but all those changes and many changes in the Constitution itself. In today's Constitution, right up at the same part, it has the same language. That was the purpose of it, to remind the jury, to remind the jury of the importance of their role in the system. And without that much elaboration, obviously, but the trial judge reminds the jury of similar things with a similar theme. And so that's the purpose of that part of the closing argument. And let me, maybe I won't have a chance to show you some of the ellipses, but let me try to, if I may. I don't know if that answered the court's question. But you'll recall that one of the issues that they made, at least in their initial brief, was that there was one juror who had an issue with the insurance company not paying. And I don't really like to refer to the jurors post-trial by their names, but they've already done it in the brief. This was Ms. Solis. And but turns out Ms. Solis also had a problem. She didn't think much of the idea of awarding damages for pain and suffering. So she was going for cause, as were other people who sympathized with insurance companies. They were going for cause. But my point is this: that the examination of the jury panel was not as portrayed in their brief. When this came up with Ms. Solis at page 517, here we are, the plaintiffs, asking the panel this. Now, does everybody understand that we are not saying that Geico is a bad company or that they're bad people? Does everybody get that and understand that? And does everyone understand from what the judge has already told you that this trial is going to be about compensating Dr. Sal for injuries that she sustained? Does everybody understand that from what the judge said? In other words, Geico's already admitted negligence on the part of the uninsured motorist, so it's going to be a question of awarding damages. So there was no, whipping up the jury. We went out of our way later on. For example, the judge, here's the plaintiff's counsel again. The judge mentioned that Geico denies there a permanent injury. There's a permanent injury, okay. Does everybody understand that Geico denies there's a permanent injury? That's their right. Everybody agree that they have the right to do that? Again, this is the plaintiff asking the panel.
Yeah, so you're down to about 4 minutes, a little bit more than 4 minutes.
All right, Judge, thank you. And, as for, I got to say this about the quote from Martin Luther King Jr. Before counsel even said what the quote was, just when he said Martin Luther King Jr., there was an objection. All right, there was an argument that this was some kind of racial appeal. And I'm sure in Geico's mind, that probably was. But the interesting thing is that the quote was that it's never too late to do the right thing. And the trial judge said, you know what, I believe that's inscribed on the cornerstone down in the courthouse when the jurors come in. And so, but Geico argues, well, it's a racial pandering, inflammatory, but we don't have to indulge Geico's speculation because we have a record, and the objection was overruled, and counsel went right back and said, now continue with my argument about what the right thing to do is. You have three important jobs. One of those jobs is to base your verdict solely on the evidence you've heard in this courtroom. Your second job is to follow the law that the judge gives you. Your third job is to make sure that your fellow jurors do the same thing. Now, are we to believe that our citizens, our jurors, are so delicate and so sensitive that they can hear a quote from, I don't know, George Washington or William Shakespeare or Winston Churchill, maybe, who said something about Americans doing the right thing one time. But they can't, but they're too fragile and delicate to hear a quote about it's never too late to do the right thing from Martin Luther King Jr. I mean, frankly, that argument is, I would say, just a little bit insulting. You know, our jurors are stronger than that, I think.
Got about a minute and a half, and that's my last warning to you.
Well, I appreciate that. I would say that, you know, context is everything. And so when you look at responding to this charge of fabrication or exaggeration, you also have to, especially rebuttal argument, you got to look at Geico's argument. And in there, you will see they repeatedly talked about their legal rights, their right. They talked about they have the right to do this, the right. Hang on a second. Page 2876, for example. We do dispute permanency, and we'll go over why we dispute that, which we have the right to do. Page 2888. So we brought experts as we have the right to do. And we have the right to have that person examined with an independent examination. So they're hammering about their rights. And when we get up and we talk about the right role of the jury in our system, it's in part in response to that, and it needs to be taken in context. Thank you very much, Judge. Your honors.
All right, thank you. Since appellant exhausted her time, we will be in recess, and thank you both for your presentations.
May we leave the meeting now, Judge?
Yes.
Thank you.